Good afternoon and welcome to this webinar on apprenticeships, key issues and potential pitfalls. My name is Emma Tegerdine and I'm an employment partner at Gunnar Cook. Many people think of apprenticeships as being limited to sectors such as the manufacturing and construction industry, and certainly apprenticeships are popular in those sectors. However, apprenticeships are now available in a much wider range of sectors than was previously the case. And this diversification has meant that significant numbers of people are still working under apprenticeship agreements. This webinar will cover the legal status of apprentices, the difference between common law and statutory apprenticeships and why you need to be aware of it, terminating apprenticeships and some of the issues that may arise there, national minimum wage issues, some key points relating to the Apprenticeship Levy, and we'll also look at some practical tips for employers. So first of all, what are apprenticeship agreements? The concept of the apprenticeship was originally developed hundreds of years ago when skilled tradesmen would engage trainees cheaply in return for food, lodging and training. These days, apprenticeships are work-based training programmes which lead to nationally recognised qualifications. Apprenticeships are open to anyone over the age of 16 and are available at various levels. An apprenticeship can be for a fixed term of between 1 and 4 years or until a certain qualification is reached. Most apprentices work for at least 30 hours a week, and the majority of apprenticeships are either wholly or partly government funded. Employers must comply with the rules which specify the minimum duration of apprenticeships in order to receive government funding. From the 1st of August 2012, the minimum duration for apprenticeships for 16 to 18-year-olds is 12 months, and for apprentices who are over 19, apprenticeships usually have to last between 1 and 4 years, unless prior learning or attainment has been undertaken. Apprentices are often relatively young. However, employers should be careful not to discriminate against apprentices on the grounds of their age. The government often provides better funding for younger apprentices. However, it is risky for employers to put an upper age limit on applicants for apprenticeship schemes on the basis of eligibility for funding, as this could potentially amount to age discrimination, although it may be possible to justify it. Employers should consider whether the apprentice's terms of employment are consistent with the terms that are offered to other employees, and if they aren't, ensure that any difference can be justified. It is not unlawful age discrimination to pay an apprentice less than the adult rate for the national minimum wage, assuming that the apprentice qualifies for the apprenticeship rate. If an employer chooses to pay an apprentice more than the applicable minimum wage but less than other employees, it is likely that the employer will be able to justify the lower pay on the basis of market forces or the need to reward skills and experience. Although there are different types of apprenticeship, all apprentices are employees and have full employment rights. Broadly speaking, there are two different types of apprenticeship in England. On the one hand, there is the traditional contract of apprenticeship, the form and status of which is governed by case law, which goes back hundreds of years. And on the other hand, there are statutory apprenticeships. This is a relatively new concept, and the form and status of statutory apprenticeships is governed by legislation. There is currently one type of traditional apprenticeship and two types of statutory apprenticeship in England. There is the traditional contract of apprenticeship, and then in terms of statutory apprenticeship agreements, there is the Apprenticeship Agreement and also the Approved English Apprenticeship Agreement. So those last two are both statutory forms of apprenticeship. Traditional apprenticeships in England and Wales are called contracts of apprenticeship and are governed by the common law. That means they're governed by case law. Historically, all apprenticeships were governed by a contract of apprenticeship, and the law relating to all of those contracts was governed by case law. However, in 2011, a new statutory form of apprenticeship was brought into force, and that type of apprenticeship is called an apprenticeship agreement. Then, in 2013, following a period of consultation, the government decided to simplify statutory apprenticeships. As a result, changes were introduced in the legislation and approved English Apprenticeship Agreements were introduced with effect from 2015. In terms of the traditional form of apprenticeship, the contract of apprenticeship, it does not need to even be in writing, it doesn't have to be in any particular form, and it doesn't have to contain any specific provisions. A contract of apprenticeship is of a special character and is different from standard contracts of employment because its essential purpose is training. The execution of work for the employer is a secondary thing. The most important thing that employers need to be aware of is that if an apprentice is employed under a contract of apprenticeship, which will be the default position if nothing else is done, they will have all the rights that other employees have. However, in addition, those apprentices have enhanced rights on termination compared to other employees. And we'll talk about that a little bit more later on. So what is an apprenticeship agreement? So an apprenticeship agreement is a statutory apprenticeship, and it was created as a way of encouraging employers to recruit apprentices. Apprentices working under statutory apprenticeship agreements have the same employment law rights as ordinary employees, and they don't have the enhanced rights on termination that common law apprentices have. For this reason, they are far more favourable for employers. However, in order to come within the definition of an apprenticeship agreement for these purposes, the apprentice's contract must contain certain information. The following conditions must be satisfied in order for an agreement to qualify as a statutory apprenticeship agreement. It must be in writing. It must state that the apprentice agrees to work for the employer. The agreement must contain the particulars that are required in contracts of employment by Section 1 of the Employment Rights Act 1996. The agreement must include a statement of the skill, trade or occupation for which the apprentice is being trained under the relevant apprenticeship framework. The agreement must state that it is governed by the law of England and Wales, and also it must state that it is entered into in connection with a qualifying apprenticeship framework. So those are the conditions that must be satisfied for a statutory apprenticeship agreement to exist. As I mentioned previously, a review of apprenticeships took place in 2013, and as a result of that review, it was recommended that the statutory provisions relating to statutory apprenticeships should be simplified, and that employers should be allowed to design their own apprenticeship standards for different sectors of work. The legislation was therefore amended in 2015, and a new type of statutory apprenticeship was introduced at that time, called an approved English apprenticeship. Apprenticeship frameworks are gradually being phased out, and they are being replaced by approved apprenticeship standards. Let's look a little bit then at the requirements for an approved English apprenticeship. A person will complete an approved English apprenticeship if they achieve the approved apprenticeship standard. There are different standards for each sector and type of apprenticeship, which will specify the outcomes the apprentice is required to achieve in order to complete the apprenticeship. An approved English apprenticeship agreement provides for an individual to work as an apprentice in a sector for which the Secretary of State has published an approved apprenticeship standard, provides for the apprentice to receive training in order to assist the apprentice to achieve the approved apprenticeship standard in the work done under the agreement, and must also satisfy any other conditions which are specified by the Secretary of State. Approved English apprenticeship agreements must also contain the particulars of employment which employers are required to give to all employees under Section 1 of the Employment Rights Act 1996. They must specify the amount of time which will be spent doing off-the-job training, and the practical period must be specified in the agreement and must be at least 12 months. Approved apprenticeship standards replace apprenticeship frameworks in respect of approved English apprenticeships. However, in sectors where a new apprenticeship standard has not yet been published, the old apprenticeship frameworks continue to apply. The new approved apprenticeship standards are designed by employers. The Secretary of State publishes the standards for different sectors of work. Each standard describes the sector of work to which it relates and sets out the outcomes apprentices who are seeking to complete an approved English apprenticeship are required to achieve. The Institute of Apprenticeships is responsible for the approved apprenticeship standards. You can find out whether there is an approved apprenticeship standard for a particular sector by looking at the government website, which is in the slides. The legislation which came into force in 2015 contained transitional provisions relating to the phasing in of these new approved English apprenticeships. Under the transitional provisions, if a person had already entered into an apprenticeship agreement in connection with an apprenticeship framework before the 26th of May 2015, the old rules relating to apprenticeship agreements will continue to apply. If a person enters into an apprenticeship in a sector where an approved apprenticeship standard has not yet been introduced, after the 26th of May 2015, the old provisions relating to apprenticeship agreements will also continue to apply. However, if an apprenticeship is entered into after the 26th of May 2015 in a sector where there is an approved apprenticeship standard, the new rules will apply to that apprenticeship. It is important to be aware that the statutory framework for apprenticeships in Wales was largely unaffected by the changes that were introduced in 2015. Welsh apprenticeships continue to be regulated by the legislation which came into force in 2011. So, in order to ensure that an individual is engaged under a statutory form of apprenticeship, it is important to find out which set of rules apply and ensure that a written agreement is given to the individual which contains the relevant required clauses. There are a number of cases in which there has been confusion about whether an individual is a common law apprentice, a statutory apprentice, or just a plain employee, and we're going to have a look at some of those now and some of the implications of those issues. Apprentices who are engaged under traditional contracts of apprenticeship have better rights than ordinary employees, whereas apprentices who are engaged under statutory apprenticeship agreements or statutory approved English apprenticeship agreements can be treated in the same way as other employees. What type of contract an apprentice has will depend on the wording used in the contract the apprentice is given. An apprentice will only be engaged under an apprenticeship agreement or approved English apprenticeship if the contract which is given to the apprentice satisfies the very specific statutory requirements. An agreement which states that it is an apprenticeship agreement but which, for whatever reason, does not comply with the necessary formalities to qualify as a form of statutory apprenticeship is likely to be treated as a traditional contract of apprenticeship instead. For example, there is a requirement that a statutory apprenticeship agreement states that it is entered into in connection with a qualifying apprenticeship framework. This may seem like a minor technical detail. However, if that statement is absent, the resulting agreement is likely to be a contract of apprenticeship, which will be far more onerous for the employer. Although there are no reported cases on the question of whether a purported apprenticeship agreement or approved English apprenticeship agreement that does not comply with the relevant statutory requirements will be a contract of apprenticeship, there is case law which relates to a previous type of statutory apprenticeship called a modern apprenticeship. In those cases, it was held that agreements which purported to be modern apprenticeship agreements were in fact traditional contracts of apprenticeship due to defects in the way they had been drafted. This means that if an employer fails to include all the relevant provisions for the contract to qualify as an apprenticeship agreement or approved English apprenticeship agreement, it is likely to have inadvertently created a traditional contract of apprenticeship, and this will be far more onerous for the employer. An example of this kind of issue is the case of Axis Telecom and Servizon. Axis Telecom and Servizon Limited have been served notices for failure to pay the national minimum wage by HMRC in relation to a substantial number of their employees. The employers argued that they had not breached the national minimum wage regulations because the affected employees were apprentices and so were only entitled to the apprenticeship rate of the national minimum wage. It was accepted by all parties that the employer had intended to set up an apprenticeship scheme and engage the workers as apprentices. However, the workers had been given statements of terms and conditions of employment, which set sales targets and which stated that the employer could terminate their contracts if they failed to achieve the targets. The agreements also provided for minimum statutory notice periods. The wording of the agreements was virtually identical to a standard employment contract. The Employment Tribunal concluded that the workers were in fact employees rather than apprentices. The Tribunal referred to the fact that the primary purpose of a contract of apprenticeship is training and the work is secondary, which was not the case on the facts, and referred to the fact that the contracts were not of a fixed duration, and the fact that it was not clear when the arrangement will come to an end. As a result, the companies were ordered to pay arrears of pay of almost £100,000, together with penalties of £5,000 each. In Wallace and CA Roofing Services Limited, Mr. Wallace was not given a written contract of apprenticeship. However, his written terms and conditions stated that he was an apprentice sheet metal worker and included a provision that at the end of your apprenticeship your employment will terminate unless there is a suitable vacancy that we can offer you at the time. The period of the agreement was 4 years, but the written terms referred to the statutory minimum notice periods. Mr. Wallace was made redundant after 19 months owing to a reduction in work. He claimed that his contract was a contract of apprenticeship and could not be terminated for that reason. The High Court agreed, holding that the agreement under which he was employed was a contract of apprenticeship rather than a contract of employment. The court commented that the contract of apprenticeship is still a distinct entity at common law, and so the ordinary employment law rules relating to dismissals did not apply. It was not open to the employer to terminate the apprentice's contract on the grounds of redundancy, unless the business was closed or there was a fundamental change in the business. As a contract of apprenticeship was in place, the notice provisions in the contract did not overrule the common law relationship, and it was unlawful for the employer to terminate the contract on the grounds of redundancy. The case of Chassis and Cab Specialist Limited and Lee also centred around a dispute as to what type of agreement an individual had. In that case, the employer was a small business which carried out car bodywork repair. Mr. Lee was introduced to the employer by a company which arranged schemes which combined on-the-job training with education. Mr. Lee started a formal programme, working towards a Level 2 NVQ. He and the employer signed an individual learner plan on a form provided by the company who had introduced Mr. Lee to the employer, under which it was agreed that Mr. Lee would continue to receive on-the-job training, but would also have day release to a college. The plan was expected to last 2 years. An individual learner record was created, which described the agreement as an apprenticeship programme, and the employer referred to Mr. Lee as the apprentice. The following year, the employer brought the arrangement to an end owing to a shortage of work. Mr. Lee claimed that he had been entitled to be paid the national minimum wage during the time that he had worked for the company. Employers were not obliged to pay the national minimum wage to workers working under contracts of apprenticeship at the time. The Employment Appeal Tribunal held that Mr. Lee had been employed under a traditional contract of apprenticeship rather than an employment contract, so had not, according to the applicable law at the time, been entitled to the national minimum wage. This was because the essential purpose of the arrangement was to provide Mr. Lee with training so he could achieve a qualification. The fact that the term apprentice was not used in the documentation between the employer and Mr. Lee was not particularly important. It was the substantial character of the relationship that mattered. The Employment Appeal Tribunal pointed out that as a consequence of it finding that Mr. Lee had been an apprentice, he would be entitled to substantial damages for the early termination of his contract, which could not be lawfully terminated on notice in the way an employment contract could be. Although Mr. Lee had not brought a wrongful dismissal claim in the Employment Tribunal, it was still open for him to bring such a claim in the court. In contrast, the Employment Appeal Tribunal decided that trainees working at a livery yard and horse riding centre were not apprentices for the purposes of the national minimum wage in the Commissioners for HMRC in Jones. In that case, the respondents traded as Home Scales Riding Centre, which was a riding school open to the public for riding lessons and livery services. The riding centre employed livery stables trainees. The trainees performed various duties for the riding school, including horse maintenance and teaching riding lessons, received training towards recognised professional qualifications. The riding school would pay for the exams, which the workers could choose to take whenever they wanted to, and lived in the family home, which was attached to the riding school. Livery stables trainees would usually leave the riding school once they had attained a certain level of qualification and could look after up to 4 horses. When the minimum wage legislation was introduced, the respondents were advised that they were exempt from paying the national minimum wage to the trainees because the work being carried out related to the family household. However, the Employment Appeal Tribunal held that the trainees were not apprentices but were employees, as the arrangements were very much for the employer's benefit and the training aspect was incidental. The provisions in the trainees' contracts relating to notice and the power to dismiss for gross misconduct were inconsistent with the contract of apprenticeship. In addition, the fact that there was no fixed term was inconsistent with the contract of apprenticeship. The Employment Appeal Tribunal emphasised the fact that the primary purpose of a contract of apprenticeship is training, and the characteristics of any written contract must be considered to determine whether they are consistent with apprenticeship status. The riding centre would have been liable to pay the national minimum wage at a much lower rate if it had successfully argued that the trainees were apprentices. We're going to turn now to a key issue, and that is terminating apprenticeships. If an apprentice is engaged under a statutory apprenticeship agreement or a statutory approved English apprenticeship agreement, the usual rules relating to unfair dismissal and breach of contract will apply. That means that if an employer has concerns about the apprentice's conduct or performance, it can deal with the matter as a disciplinary issue in the normal way. It is common for apprenticeship contracts to make provision for early termination in the same way as an ordinary employment contract and provide for dismissal with, and in some cases without notice, in cases of misconduct, poor performance, failure to meet training requirements, and so on. However, the existence of any such contractual provisions will not necessarily mean that any dismissal is fair. Fairness will depend on reasonableness, taking into consideration all the circumstances, including the size and resources of the organisation, and the procedure which is used by the employer leading up to dismissal. The expiry of an apprentice's fixed-term contract will count as a dismissal for the purposes of the Employment Rights Act. Dismissal on expiry of a fixed-term contract is treated in the same way as an express dismissal for unfair dismissal purposes, which means that an apprentice who completes his apprenticeship and is not taken on after completion may seek to claim unfair dismissal. This means that the employer will need to go through a fair procedure prior to the termination of the apprenticeship to ensure that the dismissal is fair. This is likely to involve identifying the reason for dismissal, which in most cases will be some other substantial reason, and applying the standards of a reasonable employer, which may entail warning the apprentice of the imminent dismissal and, in appropriate cases, looking for alternative employment. It is important to be aware that common law apprentices cannot be dismissed by reason of redundancy unless the business is closed or undergoes a fundamental change in its character. In the recent case of Kinnear and Marley Ethernet Limited, an apprentice roof tiler was awarded damages of £25,000 when his employer terminated his contract of apprenticeship 20 months into a 4-year apprenticeship on the grounds of redundancy following a downturn in work. If any form of apprenticeship is completed and the apprentice is not retained, the reason for dismissal for unfair dismissal purposes will be some other substantial reason rather than redundancy, which means the apprentice will not be entitled to a statutory redundancy payment. As I previously mentioned, as with any dismissal, the employer will need to be able to show that it followed a fair procedure and that the decision to dismiss the apprentice was fair in all circumstances. Even where an apprentice is taken on directly after completion of his apprenticeship, there is still arguably a dismissal for the purposes of the Employment Rights Act. This is because when an apprentice moves from an apprenticeship to full employment, although his employment has continued, it will not be under the same terms and conditions. An example of this is the case of Tantum and Travers Smith Braithwaite Services. In this case, an employment tribunal ruled that trainee solicitors are dismissed on the last day of their training contract, even if they are kept on after qualification. The reason for this is that the training contract is a fixed-term contract which is not renewed on the same terms, since the purpose of the contract has been fulfilled once the individual qualifies as a solicitor and there is no further need for the training and supervision inherent in the contract. However, there will usually be very little to gain in relation to a former apprentice bringing an unfair dismissal complaint in circumstances where they have been taken on, as the dismissal will almost certainly be fair for some other substantial reason, and even if it is unfair for some reason, it is unlikely that there would be any compensation awarded, given the offer of further employment. In the Tantum case, the dismissal of the employee at the end of the training contract was held to be for some other substantial reason and was fair. Turning now to the issue of terminating common law apprenticeships. I've already mentioned that it's not possible to terminate a common law apprenticeship at any time on the grounds of redundancy unless very extreme circumstances apply. But it's very difficult to terminate common law apprenticeships for any reason. So it's much more difficult to dismiss an apprentice who is engaged under a contract of apprenticeship than it is to dismiss an apprentice who is employed under a statutory apprenticeship agreement or statutory approved English apprenticeship. The enhanced protections apprentices have comes from the fact that the primary focus of a contract of apprenticeship is on training rather than the work the apprentice is doing. The ordinary law on dismissal does not apply to contracts of apprenticeship. The contract can be brought to an end by some fundamental frustrating event or repudiatory act, but not by conduct that would ordinarily justify dismissal. There is much less scope for dismissing apprentices on misconduct grounds than there is in ordinary employment law. Common law apprentices cannot be dismissed on the grounds of misconduct unless the nature of the misconduct is so serious that the apprentice is unteachable. If an employer terminates a common law apprenticeship early, the apprentice will be entitled to damages for his loss of earnings and training during the remainder of the term of the apprenticeship agreement and for the diminution of his future prospects. Damages can therefore be very significant, taking into account the remainder of the term of the apprenticeship, as well as loss of training and impact on future earnings. In the case of Dunk and George Waller and Sons, Mr. Dunk entered into a 4-year apprenticeship. For the first couple of years, he worked reasonably well. However, he struggled with his exams, and when he failed a particular exam, his employer decided he was unlikely to pass it and terminated the apprenticeship. In Dunk, the court held that the apprentice's earning potential for the 2 years after he completed his apprenticeship would have been better if he had been allowed to complete it. However, after that his earnings would not have been any higher due to the fact that he wasn't actually very good. Another example of a case in which it was unlawful for an employer to dismiss a common law apprentice is the case of Shortland and Chantrell. In that case, an apprentice was dismissed for swearing at the managing director after the managing director criticised the apprentice's work. Dismissal in those circumstances was considered to be too harsh, particularly as it was a one-off incident and the apprenticeship only had 10 months left to run. So it is very important, particularly if an individual is or may be employed under a traditional contract of apprenticeship, to take extreme care prior to terminating the apprenticeship. Let's look at some other issues now relating to apprenticeships. The national minimum wage, first of all. So the government introduced an apprenticeship rate of the national minimum wage in 2010. Apprentices are entitled to receive the national minimum wage, but there are special rates for young apprentices who are in the first year of their apprenticeship, or who are in the first year of their apprenticeship. Apprentices will be entitled to the apprenticeship rate of the national minimum wage if they are employed under any kind of apprenticeship agreement, whether it be a common law one or a statutory one, and they are either in the first year of their apprenticeship or they are aged under 19, or both, of course. Apprentices who don't satisfy those conditions will be entitled to the standard national minimum wage rates, which means that a lot of apprentices will get the standard national minimum wage. So apprentices who do not satisfy the second condition will be entitled to either the development rate of the national minimum wage or the adult rate, depending on their age. The training element of the apprenticeship is usually either partially or entirely government funded. Turning now to the question of working time. Under the Working Time Regulations 1998, the definition of a worker includes an individual who is employed under a contract of employment or any other contract, whether expressed or implied, whereby the individual undertakes to do or perform work personally, to do any work or provide services for another party. Apprentices will therefore benefit from all rights that workers are entitled to under the Working Time Regulations, whether they are employed under a contract of apprenticeship or a form of statutory apprenticeship agreement. Apprentices who are under 18 will benefit from additional protection under the Working Time Regulations on the grounds of their age. Employers have more onerous health and safety obligations towards workers who are under 18. An employer who offers work to a person who is aged under 18 is required to carry out a risk assessment, taking into account the individual's inexperience, lack of awareness of the risks, and immaturity. Employers should be aware that apprentices are entitled to statutory maternity, paternity, adoption, shared parental pay and sick pay, subject to satisfying the usual eligibility requirements. We're going to look now at some issues relating to the Apprenticeship Levy. In 2017, the government introduced changes to the way apprenticeships are funded by introducing the Apprenticeship Levy, introducing a new co-investment rate to help smaller employers, and introducing the National Apprenticeship Service. The Apprenticeship Levy is payable by employers through PAYE, alongside income tax and national insurance contributions, with effect from the 6th of April 2017. The rate of the levy is 0.5% of pay bills over £3 million in the relevant tax year. The levy is payable by the entity that is liable for employers' national insurance contributions in a tax year, and their pay bill is the total amount of earnings on which the employer is liable for secondary NICs in that tax year. The levy is effectively a 0.5% tax, which is imposed on employers who have a pay bill of over £3 million per year. According to government estimates, less than 2% of employers are liable to pay the levy. For the purposes of calculating the levy, employers' NIC thresholds are ignored, and an employer is treated as liable for NICs on earnings even if the applicable rate is 0% because a worker is under 21 or an apprentice is under 25. If companies or charities are connected, the obligation to pay the levy arises if the aggregate of their pay bills for the relevant tax year exceeds £3 million. The money which is generated by the levy goes into a central apprenticeship training fund. Employers who pay the levy can recoup the money they've paid in by purchasing apprenticeship training from approved training providers. For non-levy paying employers, or employers who don't have sufficient funds in their digital account, i.e. they haven't paid enough in, the government will contribute 90% of the cost of apprenticeship training, subject to a cap, provided that the employer pays 10%. This is called co-investment. An employer who wishes to take advantage of apprenticeship levy funding is required to enter into a mandatory contract with the Education and Skills Funding Agency. Employers are not permitted to recover the levy charge from any payments made to the worker. The Education and Skills Funding Agency published guidance for levy-paying employers which came into effect in May 2017. The guidance explains what an apprenticeship is and what can be funded. The rules which are contained in the guidance form part of the levy-paying employers' apprenticeships employer agreement with the Education and Skills Funding Agency. The guidance states that if an employer wishes to access apprenticeship levy funding, apprentices must not be asked to make a financial contribution towards their training, even if they leave their training before they have completed their apprenticeship. This means that training and assessment costs cannot be recovered from apprentices. The consequence of this appears to be that apprenticeship agreements between levy-paying employers and apprentices cannot include a clause which stipulates that training costs must be repaid if an apprenticeship is terminated early. The prohibition does not appear to apply to non-levy-paying employers, which means that they may be able to recover the 10% of the training costs they have incurred. Responsibility for calculating and paying the levy lies with the employer. If HMRC becomes aware that the apprenticeship levy has been underpaid or that an excessive amount has been repaid, it may issue an assessment to collect the estimated amount due. Employers are required to retain copies of all documents which relate to the apprenticeship levy for at least 3 years. An employer who has a pay bill is entitled to an apprenticeship levy allowance of £15,000 to offset against any levy liability. However, if 2 or more companies are connected, they will only be entitled to one £15,000 allowance between them. Employers can be required to pay penalties for errors in apprenticeship returns, for failing to make apprenticeship returns on time, and for failing to pay the levy on time. Substantial penalties can be imposed on employers by HMRC in respect of payments required under the apprenticeship levy, in the same way as they can be imposed in relation to tax liabilities. We're going to finish now by looking at a few other miscellaneous issues connected to apprenticeships, and then we'll look at some practical tips. First of all, it's important to be aware that it is now an offence for a person providing or offering a course or training wholly or partly in England in the course of a business to describe it as an apprenticeship when it is not a statutory apprenticeship. The purpose of this provision, which was introduced in 2017, is to protect the term apprenticeship from misuse and ensure that low quality courses that do not meet the requirements of statutory apprenticeships are not described as such, to avoid damaging the reputation of the scheme. The idea is that protecting the term from improper use will also give employers more confidence in the quality of the schemes. The National Apprenticeship Service is an online service that allows employers to choose and pay for apprenticeship training and coordinates the delivery of apprenticeships in England. The Public Sector Apprenticeship Targets Regulations 2017 came into force in 2017. These regulations require prescribed public bodies with 250 or more employees in England to have at least 2.3% apprenticeship starts each year, which can be aggregated over a 4-year period. Academy schools and other qualifying academy proprietors are subject to the public sector apprenticeship target regime with respect to the reporting period beginning 1st of April 2018 if they have a headcount of 250 or more on the day before the reporting period begins. We'll finish by looking at some practical tips for employers. Make sure there is a written apprenticeship agreement. Check which statutory regime applies and whether there are approved apprenticeship standards in relation to that sector, and draft the agreement accordingly. It's important that the correct conditions are satisfied and that a written agreement is provided. Make sure a written contract is issued before taking any steps to terminate an apprenticeship prior to completion. So ensure that a contract has been issued, ensure that it complies with the necessary conditions, and take advice before terminating any form of apprenticeship agreement, particularly if you terminate before the end of the apprenticeship. Extra care must be taken before terminating an apprenticeship early if the apprentice has not been engaged under a statutory form of apprenticeship. In most cases, if there is not a statutory apprenticeship agreement in place of either type, it will be unlawful to terminate the contract early. When drafting contracts for apprentices, check whether an approved apprenticeship standard applies and make sure that the contract is either drafted as a statutory apprenticeship agreement or as a statutory approved English apprenticeship agreement, depending on which regime applies. An apprenticeship agreement is almost invariably for a fixed term. However, as long as the written agreement satisfies the conditions of the applicable statutory regime, you can include provisions for early termination. Include details of the apprenticeship. If college hours are known, refer to these in the agreement. You may also wish to include a provision that states that failure to maintain college attendance or achieve certain qualifications will amount to conduct which could lead to dismissal. Consider including a clause which states that failure to attend the relevant course or successfully complete exams may result in the contract being terminated. Levy-paying employers must not ask an apprentice to contribute financially to their training, even if they leave early. However, non-levy-paying employers should consider including a repayment clause, which is triggered if the apprentice leaves before he completes the apprenticeship, and which requires the apprentice to repay any training costs that have not been covered by government funding. Any repayment of training cost clause must be very carefully drafted, otherwise it is unlikely to be enforceable. This webinar has covered the legal status of apprentices, the difference between common law and statutory apprenticeships, termination of apprenticeships and some issues around that, national minimum wage issues, the apprenticeship levy, and we've also looked at some practical tips. My name is Emma Tegerdine. I'm an employment partner at Gunnar Cook. I hope you've enjoyed this webinar and found it useful. If you have any questions or if I can help in any way, please do not hesitate to contact me. Thank you.